about my religious beliefs. And I'm really getting tired of the fact that it seems like a lot of the administration here in St. Joseph County commits felony perjury and felony official misconduct, and it goes unpunished, which forces me to have to file paperwork with the Indiana Supreme Court and the federal Supreme Court in order to get redress.
Okay, so you understand that you still have to follow the rules of the jail in order to access
Unfortunately, the rules of the jail can't interfere with my constitutional rights.
You know, here's the thing, sir. Stop. You don't get to do just whatever you want. There are rules. There's procedures that are established. When you come to court, you can't wear stuff. When you go to the law library, it has to be when the staffing is reasonable.
So my problem with that is that I filed multiple grievances about using the law library. I wasn't allowed to do so, and then Warden Finn came here and said
during business hours.
And then Warden Finn came here and stated that I never requested except for one time. That is a lie. Grievance record clearly show that I requested over a dozen times, and I submitted a filing with this court that had all of the grievance numbers listed, which was ignored completely in December because Warden Finn committed perjury about it. I requested multiple occasions, all of which were during business hours between the hours of 8 a.m. and 5 p.m. and every single one of them was returned to me as invalid request or request refused while I had an active court order to do so.
Do you have copies of those?
Yeah, he won't give me an actual physical copy of it because he says I have to have a court order to get my grievance records from the jail because of the incriminating evidence against him. Furthermore, me not being allowed to come to court for wearing a kufi is a violation of Indiana's Religious Freedom Restoration Act, which is Indiana state law. I, in fact, have the right in this state to express my religion without restriction. That is Indiana state law, no policy, and it specifically states no policy or administrative ordinance can interfere with that. So in fact, the jail trying to enforce something that is illegal under Indiana statute is not my problem.
Okay. So as it pertains to 126, you're not ready to go to trial. You're asking for a continuance. How much time do you think you need reasonably?
I need all of the evidence presented to me that's been being denied to me since May, and we can go from there.
Okay. Well, I want to put it on the trial calendar for you so that we have a date. If we just leave it open, I know that you're concerned about getting this done in a timely fashion based on the filings. So I know that I don't want to just leave it hanging out there for forever. If we set it to May 11, does that work for you, sir?
As long as the state of Indiana produces all the evidence.
We're gonna talk about that too, but the date of May 11th, is that okay with you, sir?
Well, like I said, as long as I can have the evidence that the state has been holding back.
Okay.
Because there is video of Matthew Sterling watching the surveillance unit with audio, going through phone records, all of which
I don't need to know about the particularities of the evidence. I just need to know whether or not you can be ready to go to trial. So state, there's been a lot said, but do you have anything that hasn't been turned over?
You're the only thing that I actually brought was and Mr. Peppers had filed some filings regarding this. A search warrant to obtain Mr. Peppers' DNA was submitted and executed earlier, I think late December, early this month. So I just got copies of that, and then the state lab did complete the DNA results and a copy of those results. A copy was mailed, and I emailed a copy to the jail staff. I did bring a physical copy just in case. And as far as items, I mean, Mr. Peppers has listed quite a few things that I'm not aware of necessarily existing. That's not to say that they're not out there, they're just not maybe in what we have right now.
I'd like the record to show that I'm trying to give the state of Indiana the warrants for the evidence of which they claim that they don't have. And I'd also like to point out that they filed a filing a couple of months ago stating that they haven't actually reviewed any of the evidence that Matthew Sterling has, that they've been taking his word on it when they stated that the indictment wasn't fatally defective because they're accusing me of doing a crime on May 15th, not May 17th.
All right, so Mr. Mills, this is it?
Yes, that's
being mailman.
and so
The state has proffered those things to the defendant, and the defendant has proffered his items to state. Mr. Peppers, what you just gave the state, are those your copies that you need back, sir?
No, I have several copies of them.
Okay,
So does the Indiana Supreme Court.
okay. Great.
And once again, I'd like to point out that this, quote unquote warrant is not in my name. It's in a Mr. Kilgore-Peppers, which is not me. That is a different member of my family because Matthew Sterling doesn't know who I am. Once again, in the recorded videos of Matthew Sterling, he claims to have a vendetta against who he refers to as the Peppers clan, and he continuously refers to chasing, quote, me down to my grandmother's garage, of which he's never done. He also claims that
Mr.
he's
Peppers,
dealt with me
you gotta
for years.
understand, sir, that the minutia of the evidence on a day like today isn't the thing, right?
Well, that's why I've demanded a Frank's hearing for the past 2 months. And it's just been overlooked and has silence on the record.
Okay, well, then we'll set that hearing for a couple of weeks from now.
Well, what's the date?
On February 4th at 11 o'clock. Actually, we'll move it to 10 o'clock. 10 o'clock on February 4th.
And what kind of hearing is that?
It's a Frank's hearing,
Frank?
Frank's, beans and Frank's.
And then May, what was the second date?
May 11th is your new trial date, okay, sir? And then we'll set your record date for April, State, is there any objection to continuing the trial date of January 26th?
There's no objection, Your Honor. However, the state is prepared to go. I did confirm the availability of all of our witnesses, so we were ready to go to trial next week, but because it's defense request, we requested the CR4 would be attributed to the defendant.
Sure.
Well, unfortunately, it can't be because the state has refused to provide this information that I have demanded in writing.
Mr.
Since
Peppers,
June.
you know what, here's the deal.
I mean, you can argue with the Supreme Court.
Stop. I'm not convinced that these things exist. You're telling me that you're not ready.
Oh, you mean besides the videos that I have of them? I mean, if you'd like, we can have the videos brought from the SD cards in of Matthew Sterling watching his videos with audio. I mean, that's perfectly fine. It's on video. It's not like I'm making it up. You guys have it, they know that they have it. They just don't want to acknowledge it because, quote, they're filing. They haven't even looked at it.
Well, the state has been, I don't have any reason at this point in time to believe the state has held back on.
Well, I mean,
providing
besides the
so.
perjury they committed on
Mr.
May
Peppers,
30th, August 20th,
Mr. Peppers,
September
stop
3rd.
talking.
Well, I'm just saying, they've committed perjury about not having my surveillance unit, then they had it, then they needed time to depose it, then they needed more time to depose it, then they deposed it, and they decided that they deposed it back in May, and that it doesn't have audio, even though physical evidence directly contradicts that. That is perjury by definition of the law. So you're right, you don't have any reason to not believe them besides the felony perjury and official misconduct that they've committed on the record. I would also like to know why no one's responded to my request for a certified chronological case summary and record of the proceeding to send to the Indiana Supreme Court for my writ of mandamus as required by Indiana state law that I filed multiple times, had recorded, and have a copy of that was recorded last month. I've been filing that since November and being ignored.
The clerks have been directed to comply with requirements there. So we're looking at a trial date, May 11th, record date, perhaps April 8th. That'd be a deadline for filing any motions for the 511 trial. Also a deadline for entering a plea agreement.
So that was April what?
8th
Thank you.
or 8th.
And Your Honor, just for clarification, on the DVR that Mr. Peppers has wanted to review,
Right.
that is the item that we were providing in December, and I believe again, I think twice in December,
Twice in December.
and then there was a failed transportation or refusal transport. And just for the record, the entirety of that DVR is not included in the state search warrant. So the state has not looked at the entire contents, because I
Oh, I'm
believe
clear.
there's.
That would be overly broad.
Yes, and however, it is Mr. Pepper's property, so if Mr. Peppers chooses to examine that in its entirety, then it is likely that the state would request to also have access to that and expand But at this juncture, we have no reason to request looking beyond what is in the warrant.
Right.
And I do have access to that unit. I've put that in writing many, many, many times. And according to all the documents I've been served, nothing that's been seized from my home and place of business is even remotely being considered as evidence, and yet none of it's been returned to me.
Well, I don't know about returning property to somebody who's in custody, but the essence of what we're talking about with that unit is that you were provided an opportunity twice in December to come over and have access to that unit and review whatever you wanted to on there, and you just declined to come over.
I did not decline. I was refused transport by St. Joseph County Jail, as I've stated multiple times.
Understood, but either way, it didn't pan out, and the state was prepared to have that available to you, and the court had prepared a place for you, and all of that. So, and you understand that when the state says that they've looked at that unit, they've looked at what was specified on that search warrant, which is between X date and Y date. They haven't looked at the whole entirety of whatever might happen to be on that unit, because that would have been overbroad, and they respected your constitutional rights.